All right, let's talk about something really interesting. A legal doctrine that's supposed to be a shield for our national security. But there's this huge debate bubbling up, and the big question is that shield turning into something else? Maybe a blank check for government agencies. And that really gets to the heart of it, doesn't it? When a government agency just says the words national security, does that mean all the other rules, all your rights, just go out the window? It's a massive question, and it's exactly what we're digging into today. So, to really wrap our heads around this, we're not going to start with a bunch of dry legal text. Instead, we're going to look at the story of one single employee. Because their case, wow, it just perfectly shows how this doctrine can stop feeling like a shield and start feeling a lot more like a sword. Okay, so here's the setup. An agency takes action against one of its employees. Now, the real reason, the root of it all, is a medical issue. But the agency, they just slap a label on it, security concern. And boom, just like that, with those two little words, they try to make their decision completely untouchable, totally shielded from any court looking at it. So you're probably wondering, what is this powerful tool they're using? What is this thing that lets them do that? Well, let's break down what's called the Egan doctrine. We need to understand what it was originally for and why using it here is causing such a stir. All right, so the Egan doctrine, it comes from a big Supreme Court case. And, at its core, it's all about one word, deference. It basically tells courts, hey, don't second-guess an agency's expert opinion. Their predictive judgment, which is just a fancy way of saying their best guess on who they can trust with the nation's secrets. This is specifically for when they're deciding to grant or, take away a security clearance. Now, what's really important here is that the Supreme Court drew a very clear line in the sand. Egan is only for that formal, official process of deciding on a security clearance. It was never, ever meant to cover things like routine day-to-day management, medical issues, or an agency refusing to provide a reasonable accommodation. That difference, it's everything. And right there, that's where the trouble starts. The whole argument here is that this very specific, very narrow legal shield is being stretched and misapplied to cover the exact kind of stuff it was never supposed to touch. And when you put it side by side like this, the disconnect just jumps right out at you. On one hand, you have what Egan was meant for, a formal security clearance decision. But then you look at what's happening in this case. It's not a formal clearance action at all. It's just a regular personnel decision, and the justification is this kind of vague claim about trust. See the difference? There was no official action on the clearance itself. Okay, let's get into the nitty-gritty, the actual facts of this case, because they're pretty wild. First off, the employee's security clearance, it was never suspended or revoked. In fact, multiple reviews actually reaffirmed it. Second, security looked into it and found absolutely zero misconduct. No compromise, nothing. So what was the problem? The only issue found was a medical one. A psychologist said the person was unfit to take a polygraph test. That's a clinical diagnosis, right? Not a security finding. And if you think that's something, here's the real kicker. The case isn't just about the agency stretching the Egan doctrine too far. Nope. The argument is that the agency flat out broke its own rules. We're talking mandatory, you have to do this regulations. Okay, violation number 1. The Department of Defense has a rule that's crystal clear. It says if an employee is deemed medically unfit for a polygraph, you have to either postpone it or just exempt them. It's not optional. It's a mandate. And in this case, the agency just didn't do it. Then you've got violation number 2, which is just as blatant. The regulations are super explicit. You can't take negative action against an employee only because of an inconclusive polygraph test. That's a big no-no. And yet, that's pretty much exactly what seems to have happened here. And this is where it all comes together from a legal standpoint. Think about it. The whole point of Egan is to protect an agency's discretion, their ability to make a judgment call. But what happens when a rule is mandatory, when it says you must do this? Well, then there's no discretion left. There's no predictive judgment for a court to bow down to. There's just a rule, and the only question is, did you follow it or did you break it? So you might be thinking, okay, this is one person's case. Why is it such a big deal? Well, here's why. If this broad interpretation of Egan is allowed to become the norm, it creates something legal folks call a zone of unreviewability. And trust me, that's a really dangerous place to be, with serious consequences for all of us. So, consequence number 1, it basically vaporizes people's legal rights. It gives agencies a playbook, a get-out-of-jail-free card to sidestep major federal laws like the ones that protect people with disabilities. Imagine an agency refusing to provide a legally required accommodation. All they'd have to do is whisper security concerns, and suddenly they're untouchable. All right, consequence number 2. It basically makes agencies immune to oversight. Any decision they make, no matter how unfair or discriminatory, could be shielded from review. All they have to do is say the magic words, trust, security, and poof, their actions are hidden behind a wall that no court can see over. And the third consequence, this is the big one. It just fundamentally undermines the rule of law. I mean, think about it. If a powerful government agency can just ignore its own mandatory rules whenever it feels like it, what's the point of having rules at all? They just become meaningless words on a page. It sends the message that the agency believes it's above the law. But look, this fight is far from over. This isn't some settled, done deal. In fact, there's a really strong legal history of pushing back, of restoring the power of the courts to hold agencies accountable even when they're dealing with national security. You've got decades of cases that say, yeah, courts absolutely can and should step in when an agency goes beyond a formal security clearance decision. You see it in cases like Service v. Dulles, Radigan v. Holder. The precedent is there. The message is that agencies don't get a free pass to ignore their own rulebook. And the principle that comes out of all that legal history is actually really simple, but incredibly powerful. Agencies have to follow their own rules. Period. Saying the words national security isn't a license to just throw the rulebook out the window.
So all of this leaves us with a huge, critical question to chew on. Of course, we want our security agencies to have the expert judgment they need to keep us safe. Nobody's debating that. But where do you draw the line? At what point does a court showing respect for that expertise cross over into just abandoning its job to enforce the law? That's the tightrope this whole debate is walking.